are appeals in a matter of B and another, and BDB Pitmans LLP and another, and Adcamp LLP and another, and Office Properties PL Ltd.
Yes, may it please your lordships, I appear for the appellants in both of the appeals. The learned friend Mr Lawrence, King's Counsel, represents the respondent of the Office Properties case. The learned friends Mr Grant, King's Counsel, and Mr Turner appear for the respondents in the Lee case, though Mr Turner joins us only in spirit via the live stream and not in body. My lords, as you will have seen, these two appeals raise an important point which has never before been considered by this court, namely whether a claimant which has sued a defendant A in the mistaken belief that it has acquired the liabilities of another party B can, after the expiry of the limitation period, make B the defendant in place of A. And coincidentally, both of these appeals involve the same two parties, A and B, which are two solicitors' practices. In both claims, the claimants allege that a firm called Pitmans LLP was negligent in work which it undertook for the claimants. Pitmans LLP subsequently merged with another firm, Dyson Bell LLP, to form BDB Pitmans LLP, which is the same legal entity as Dyson Bell LLP and therefore a different legal entity from Pitmans LLP. And to make matters more complicated, BDB Pitmans is now called Broadfield Law UK LLP, but if it pleases the court, I'm going to refer to it as BDB Pitmans, and Pitmans LLP is now called Adcamp LLP, but for ease I'll refer to it as Pitmans. In both of the claimants issued proceedings against BDB Pitmans in the belief that it was liable for any negligence of Pitmans. And in both claims, the claimants seek to replace BDB Pitmans with Pitmans LLP, though in Lee, only contingently, because unlike in Office Properties, the claimants in Lee maintain that BDB Pitmans is the correct defendant against which they have a good claim. And in both of the cases, the judges below held that substitution was permissible. And in doing so, they followed over to the dicta of Mr Justice Leggett, as he then was in Insight Group and Kingston Smith. And my overarching submission is that with respect to Lord Leggett, those over to dicta were wrong, alternatively were misapplied by the judges below. And if the relevant statutory provision and CPR rule are properly applied, substitution is not permissible in this sort of situation. To give your lordship something of a roadmap for my submissions, I'll first of all show you what I need to about the underlying claims. I'll then go to the legislation and the rules and make some propositions which summarise my case. I'll go to the authorities and then to the judgments below, and finally deal with some of the points that are made in response by the claimants. So there's very little that I need to say about the facts of the underlying cases, but I will, if I may, show your lordships the essence of what puts these matters in issue. And so the claim form in Office Properties is in the core bundle for that appeal at page 73, it's tab 9. And we can see from this that the original first defendant was BDB Pitmans LLP. And we can see under brief details of claim the now deleted sentence, the first defendant is the successor practice to Pitmans LLP. And it's common ground that that was a reference to BDB Pitmans being a successor practice for the purposes of the SRA minimum terms of professional indemnity insurance. They require a practice, which is a successor practice, to have insurance in respect of claims against the prior practice, but they do not in themselves make the successor practice liable in place of the prior practice. And we can see in the middle of the block of text under brief details of claim, it was said originally that Pitmans LLP acted negligently. The deleted words which are in the following line are there because the amendment in this case was actually effected in two stages. First, Adcamp LLP was added as a defendant, and then as a separate stage of amendment, BDB Pitmans LLP was removed as a defendant. but nobody suggests that that process has any relevance to the outcome of the appeal. Prior to the amendment, the claimant had provided the defendant with draft particulars of claim. They are not in the bundle, but they are quoted from in the judgment. If I can just show your lordships that briefly at page 56 in this core bundle, behind page 7.
I don't have tabs in my bundle.
I'm sorry to hear that, man.
Page numbers is
I hope that isn't too inconvenient. It's page 56.
So the same bundle.
Yes, it is, my lord.
Okay.
And it's paragraph 7 at the top of that page. And we see the judge quotes there from the draft particulars of claim, which said in paragraph 2, the italicised text, the first defendant is the successor practice to Pitmans LLP, which was at all material time the firm of solicitors advising the company the liabilities of Pitmans have passed to the first defendant, which bears responsibility for its acts and omissions. The amendments made in this case were made as of right before serving the proceedings under CPR 17.1. So the application that was before the judge below was actually my client's application to set aside those amendments, but it's common ground that nothing turns on that. Moving on to the position in the Lee case, in the core bundle for that appeal, at page 91, and for those who have tablets, tab 9, we see there the claim form. And the defendant to this claim has only ever been BDB Pitmans LLP, and that's because, as I have said, the claimants maintain that they do have a valid claim against BDB Pitmans. And we can see the alleged basis for that claim in the amended particulars of claim, which begin at page 96 behind tab 10. The relevant averments, most of which were added by way of amendment, but they are really particulars of what was said in broad terms at paragraph 7. This is page 97 of the bundle. We see, and it's easy to identify because it's all the differently coloured and underlined added text. We have 4 pages of averments that run on to page 101 of the bundle to establish the basis of BDB Pitmans' alleged liability for Pitmans' acts and omissions. And it's put in a number of ways. It's said, first of all, we see this in 7a and 7b on page 97, that Pitmans' liability was novated to BDB Pitmans by virtue of the merger agreement between the two firms. We see at 7c and 7d over the page at 98 that the claimants also rely on the published accounts of Pitmans and of BDB Pitmans. At 7g, we can see on page 99 the conclusions that the claimants draw from those factual averments. At 7h, we then see the start of averments to the effect that BDB Pitmans are in any event stopped from denying that they are liable in place of Pitmans by virtue of those published accounts and also by virtue of the pre-action protocol correspondence that we see set out in paragraph 7h, and we also see pleadings as to alleged representations in 7i. In 7j, they plead reliance. In 7k to 7n, the claimants make allegations as to BDB Pitmans' knowledge or state of mind. In 7p, the claimants plead the falsity of the alleged representations. In 7q, they plead the alleged detriment, and in 7r, they plead the estoppel. But as with Office Properties, all of the allegations of breach of duty concern only the acts and omissions of Pitmans. BDB Pitmans, of course, denies both that there is any merit in the substance of what one might call the underlying claim, but also that there is any basis on which they can be liable, even if Pitmans would be. Its response is set out in the defence beginning at paragraph 7, and that begins at page 121 in the core bundle. And it runs on to page 132, meeting all of the averments that I just showed your Lordship. And as your Lordships will have seen, BDB Pitmans applied for summary judgment on those issues, but save in one very limited respect, namely promissory estoppel, that application was unsuccessful. So the judge below held that the claimants had a real prospect of establishing all of the remaining allegations and that they are properly matters for trial. There's no appeal from that decision. So I go from there, my lords, to the legislation and the rules. Beginning with section 35 of the Liquidation Act, which is tab 2 and page 7 of the Bundle of Authorities. Starting, my lords, with subsection 1, this provides for the doctrine of relation back. Subsection 2 then defines the concept of a new claim, which under A is any claim involving the addition or substitution of a new cause of action, or under B, the addition or substitution of a new party. Subsection 3 then imposes a general prohibition on permitting new claims after the expiry of the limitation period in respect of that new claim, but it is subject to exceptions inter alia in rules of court. And then subsection 4 is the provision which enables rules of court to be made to permit such a claim, but expressly only if the conditions specified in subsection 5 are satisfied and subject to any further restrictions the rules may impose. So plainly, the subsection allows rules of court to be more restrictive than is provided for in the Act, but they cannot be less restrictive. And then subsection 5 sets out the conditions. 5A relates to claims involving a new cause of action that we're not concerned with here. Under B, the condition in the case of a claim involving a new party is that the addition or substitution of the new party is necessary for the determination of the original action. And then that takes us into subsection 6, which provides that the addition or substitution of the new party shall not be regarded for the purposes of subsection 5b above as necessary for the determination of the original action, unless either A, the new party is substituted for a party whose name is given in any claim made in the original action in mistake for the new party's name, or B, any claim already made in the original action cannot be maintained by or against an existing party unless the new party is joined or substituted as plaintiff or defendant in that action. Now, it's common ground that we are concerned with B, but it's also relevant in my submission to note the scope of A. And following Adelson and associated newspapers in this court, it is established that A requires what is referred to as a mistake as to name, as opposed to a mistake as to identity, confirming the pre-CPR test in the Sardinia Sulcus. In other words, it is available where the claimant has identified the correct description of the desired party, which might be, for example, my landlord, or my employer, or the entity which handled my conveyancing transaction, but has wrongly considered the named party to match that description. That lid is not available where the claimant has simply misidentified the party to be sued. And for example, in this case, the claimants knew when they issued proceedings that Pitmans and not BDB Pitmans had done the work which was complained of. If they made a mistake, it was a mistake in believing that liability nevertheless attached to BDB Pitmans, and that is not, on the authority of Adelson, a mistake falling within A. The relevant rules of court are behind tab 4 in the authorities bundle at page 12. It's currently CPR 19.6, but in almost all of the authorities, the identically worded rule was 19.5. So we will usually see it referred to as 19.5, but it is this rule. And in general, the rule largely tracks the wording of the statute. It doesn't seek, for example, on the face of it, to introduce a whole new raft of additional requirements or restrictions, but it does contain some changes of wording from the statute, which I submit do have some significance. We see in 19.62b, the wording there is simply that the additional substitution is necessary. The words for the determination of the original action have been removed, but obviously the rule cannot be of any broader effect than the statute. 19.63a then deals with cases of mistake, and we're concerned with B, which maps to section 35(6)b of the Act, but with a change of wording from cannot be maintained to cannot properly be carried on. So, having shown your lordships those provisions, before I go to the authorities, I'm going to reduce my case to 7 propositions.
Before you do that, can I just ask this?
Yes.
There's another difference between the rule and the Act. In the Act, the relevant wording equivalent to sub-rule 6b is any claim already made in the original action cannot be maintained or by or against the an existing party. That's in the Act 35(6) against an existing party. In the rule, the word is against the existing party. Does that make any difference in your case?
Well, in fact, my lord, it's a very slight change beyond that, because it's the original party as opposed to an existing party. And I don't understand that anybody submits that there's any significance in that change. I don't submit that there is any significance in that change.
Do you accept then that the rule at 3b can cover the case where the claim cannot properly be carried out by an original party unless the new party is substituted as a defendant?
Yes.
Yeah.
Yes, that must be right. Yes. And it's worded, obviously, so that it is directed at changes on both the claimant side and potentially the defendant side. So, my lords, I'll now reduce my case to 7 propositions, which I submit are either self-evident from the wording of the relevant provisions, or they are consistent with the authorities which bind this court. The first is a point of general application about construction of the Limitation Act from the speech of Lord Scott in Hayward and Fawcett's. That, my lords, if I can ask you to turn it up, is at page 137, tab 12 of the authorities bundle. We don't need to be concerned in any way with the facts of this case, which is about section 14a of the Limitation Act, but the observation in the speech of Lord Scott at paragraph 32 is, in my submission, of universal application in circumstances like these. So we see at around letter E, which I won't read out, that the Limitation Act strikes a balance between the interests of claimants and defendants, and therefore, beginning at letter G, Lord Scott says it is the task of the judiciary to identify from the statutory language and the purpose of each amending enactment the balance that that enactment has endeavoured to strike and to apply the enactment accordingly. It is emphatically not the function of the judges to try to strike their own balance, whether the response to the apparent merits of a particular case or otherwise. And that, as we will see, was also echoed by Lady Justice Hallett in the Nemetti case, with specific reference to section 35(6)b, that the courts must simply apply the words of the provision. My second proposition is that sections 35, 5 and 6 obviously do not provide a general discretion to do justice whenever a claimant sues the wrong party and the limitation period has expired. Parliament obviously intended that the situation would be remediable in some cases and not others, and the court's task is to identify where the dividing line lies. But the default position is that the situation is not remediable. And so the question cannot be answered simply by appealing to the justice of case. It is obviously, in my submission, not enough just to say there is a very close connection between Pitmans and BDB Pitmans, or that they share a professional indemnity insurer, or that BDB Pitmans has agreed to indemnify Pitmans in respect of the claim. Those are all plainly matters which are relevant to the exercise of the discretion if you are within the provision, but they cannot by themselves bring you within it. Thirdly, my lords, any complaint that the approach to A, mistakes as to name, gives rise to an arbitrary distinction between mistakes of fact and mistakes of law is a complaint about the interpretation of that section. And the interpretation of B cannot be driven by a desire to undo that distinction. Fourthly, in my submission, the wording of the statute and the rule point towards a problem which falls within B as being something other than the claim simply being bad on its merits, whether that is characterised as a problem of locus or formation or some other procedural issue. And I make at this stage 3 points in support of that proposition. So if we can have section 35 in front of us, back at page 8 of the authorities manual. Firstly, in my submission, we must keep in mind that what subsection 6 is doing is defining the words necessary for the determination of the original action. But we must not forget that that is the expression which is being defined, and that expression in itself is, in my submission, a guide to the true meaning of the words which define it. And as we'll see when we look at the Parkinson engineering case, Lord Justice Lloyd held that determination there means determination on the merits. So the essence of this is that there is something which prevents the claim from being determined on the merits. That's the first point. The second point is to invite focus on the word unless in 35(6)(p). And the significance of that in my submission is that it must be that the absence of the party to be added or substituted in itself prevents the claim from being maintained. And then thirdly, I make the point by reference to the use of the words properly be carried on in the rules as opposed to maintained in the statute. In my submission, that choice of words is significant. Now, there are multiple statements in the authorities that the two expressions mean the same, and I don't dissent from that. I don't make any submission that they are different. That does not mean, as the claimants suggest in Lee, that you can simply ignore the words used in the rule. What it means is maintained has to be regarded as having the same meaning as properly carried on. And simply taking the words at face value, in my submission, cannot properly be carried on, are words which imply that the proceedings are in some way defective for reasons other than their substantive merits. And that really goes hand in hand with the first point I made about this being a definition of when it is necessary for a determination of the claim. Now, it's undoubtedly difficult to apply a perfectly encompassing label to all of the circumstances at which I say that rule is directed. But I also say that I don't have to establish the precise boundaries of the rule, I just have to establish that these two cases are not within it. And I also say now, and I'll make this good in due course, that what Lady Justice Hallett said in the Netty does not prevent me from making that submission. My fifth point is that the claims before and after the addition or substitution must be the same claim. And subject to argument about what is meant by the claim for those purposes, I don't understand that to be in dispute. But it's plain from the wording of section 35(6)b and also from rule 19.63b that it is the claim made in the original action which must be saved by the addition or the substitution. And sixthly, my lords, the claim being the same, in my submission, means that the cause of action must be the same in every respect. Now that is not only clear on the authorities, but it's also baked into section 35. Because if we go, my lords, back to section 35(2) at page 7 of the authorities bundle, we see that under 2A, a claim involving the addition or substitution of a new cause of action is by definition a new claim for the purposes of that section. So it cannot be the case that substitution of a party which involved a new cause of action could result in that being then the same claim for the purposes of 35(6)b. And in practice, even if I'm wrong about what one might call the a priori construction of the provisions limiting them to procedural defects, the practical effect of proper application of the requirement that the claims be identical is going to be the same. It's going to lead to the same endpoint. And then finally, seventhly, applying those principles to the facts of these cases neither comes within the provisions. There was nothing to prevent the claims that were issued from being determined on their merits. They could be properly carried on, but they were bad claims. Now, of course, in the case of Lee, that has yet to be determined. But in my submission, that is the clearest demonstration that that case is not within section 35(6)b. By the time the claimants might need to rely on that provision, they will have carried on their claim all the way to trial and will have received a determination of its merits. But in any event, in neither of these cases is the claim which the claimants would seek to bring by way of substitution the same claim as the claim which cannot properly be carried on.
Mr Carpenter, that's very helpful outline of where you're going. Can I just take you back to the wording of 35 subsection 6?
Of course,
Certainly would help me speak for myself if I can just have some assistance from you on what you accept and what you would not accept. Looking at paragraph B, it's expressed disjunctively, and so the provision applies whether you're substituting a plaintiff or a defendant.
Yes.
Yeah. Do you accept that?
Absolutely accept that.
And what to my eyes at least seems a bit curious is where it says that the claim already made in the original action cannot be maintained unless the new party is joined or substituted. So again, that's disjunctive. So that suggests that you could have a completely new defendant.
So,
and yet, what you're trying to do is, as it were, to use my language, not the language of the statute,
yes.
You're trying to save the original action.
Yes.
So can you give me an example of where you would accept that you could substitute a new defendant?
Well, my lord, I won't shy away from saying this, that the likelihood on my case, and I accept that, is that you probably can't ever substitute a new defendant, because the likelihood, and it's certainly my case, that the basis on which a particular defendant is liable is an inherent part of the cause of action against that defendant, and therefore you are never going to meet my test if you are seeking to substitute a defendant. I have to face up to the fact that that is the consequence of my submission, but I say that's not a problem for me in terms of the legislation, because it is obviously drafted in a broad way which admits of both substitution and joinder, and also admits of the possibility of it happening on the claimant side and the defendant side, but then leaves it to rules of court if necessary to restrict matters further. And we haven't got into this, and nobody suggests that we should, but of course, as your lordships may know, before the CPR, there were very restrictive rules of court. That on the defendant side, it effectively would only have permitted joinder where you've got a case of joint debtors and you don't have a properly constituted claim only against one of those debtors, and therefore you might have to join the other. So there clearly are cases, and absolutely, except there are cases where this can work on the defendant's side. It is probably going to be limited to joinder in that sort of case. But I do say that's not a problem for me because the rule is deliberately drafted in a wide way, and then it's up to the courts actually to apply its terms. And if the effect of that is that substitution only works on the claimant side, that doesn't mean that I'm improperly cutting down the ambit of the provision. It simply means that if you actually apply its terms properly, that is going to be the practical effect.
As a matter of pure logic, if you substitute an existing party, you are not then maintaining an action against that party because they've gone.
So, yes, my lord, one does have to make sense of the words maintained by or against an existing party. And in my submission, what that means is at least one of the parties must be the same. So if it is a claimant seeking to do something on the defendant's side, what you focus on is the claim made in the original action being maintained by that claimant, because they are the existing party. If the change is on the claimant side, then what you are concerned with is whether you are maintaining the same original claim against an existing party.
It's very difficult to read that as meaning other than the existing party is the one which is substituted. Or otherwise, why would you use the word existing? You say continuing.
Well, I would respond that it doesn't say in the section joined or substituted for the existing party. It simply identifies an original action, it identifies an existing party, and it identifies a requirement that a new party is joined or substituted as plaintiff or defendant in that section. And sense can be made of all of those requirements on my construction of the statute, because you always have an existing party that remains the same, whether it's on the claimant side or the defendant side. You have an original action which you can identify, and you are seeking to join or substitute a new party on either the claimant side or the defendant side. Otherwise, it doesn't really make sense, because if you focus on whether you can if you focus on whether you can maintain the original claim against the existing party, and the existing party is the one you're substituting, I think this is my lord's point, it doesn't really make sense. Again, the position under the rules is really much the same, except that the language used is slightly different. But that says cannot be carried on by or against the original party unless the new party is added or substituted as claimant or defendant. But again, it doesn't say who the substitution is for. And at my submit, I can make the same points in relation to the rule.
Right.
So, my lord, at this point, if I may, I will embark on my tour of the authorities, which I'll deal with largely in chronological order. and the parties are agreed on which the key ones are. And they begin with Parkinson Engineering Services and Swan, which begins at page 225, tab 15 of the authorities bundle. In which the only judgment was given by Lord Justice Lloyd. Dealing with the facts very briefly that we see in paragraph 2 at page 226, a company had been in administration, the administration order had been discharged, and the company had been ordered to be wound up. And as we see from the report, and as your lordships will doubtless know, section 20, subsection 2 of the Insolvency Act grants a former administrator who has been released absolute liability in relation to acts or omissions in their capacity as administrator. And that was a problem for the claim which was sought to be brought by the company against the former administrators, alleging negligence in the performance of their duties. And so what the company sought to do was instead substitute the liquidator as claimant, so the liquidator could make exactly the same allegations, but as a misfeasance action under section 212 of the Insolvency Act. Now, the first point that I take from this is at paragraph 7 at page 227, where in the course of going through the provisions of section 35, in the final sentence of paragraph 7, he said a determination of the original claim means its determination on the merits, however they be found, may be found to be at trial. So that makes good the point that I made earlier. We can then go on to paragraph 12, where there are important observations about the nature of section 212 of the Insolvency Act, taken from a case called Pruitt Europe Limited. And we see in the quotation from that judgment of Mr. Justice Blackburn below, we see 3 lines in, the section 212 is procedural in nature. We see in the middle of that block of text, it said the procedure is not available if it is intended to make someone other than a director or other person falling in section 212 liable for the wrong to the company. For example, a claim against a non-director or wrong to the director for having conspired to harm the company. In such case, or where other claims not within section 212 are brought against the director, for example, a straightforward claim in debt, the claim must be brought by the company. In each case, however, in substance, the claimant is the company. That's an important observation. And then finally, also important, there is only, in the last 3 lines, there is only a single cause of action, that of the company. All that section 212 does is give to the liquidator, if he wishes, the right to bring the claim in his own name. And then in the following paragraph, Lord Justice Lloyd notes that there is no doubt that the claim which the liquidator seeks to assert under section 212 is identical to that which he put forward in the name of the company by the original proceedings. The proposed amendments include no change to the allegations of duty, breach or loss. References to the company are substituted for the word claimant in reference to section 212 is added to the text as regards relief. Otherwise, there is no change. We can then go on to page 232 and paragraph 26. And I'll just read part of that paragraph. It said the distinctive feature of the present case is that on the one hand, the original proceedings cannot succeed, but on the other, subject to getting leave under section 2124, the liquidator can assert exactly the same cause of action on behalf of the company and can thereby overcome the defence under section 20 for the company's own proceedings. It is therefore a case in which if the court thinks it appropriate to give permission under the section, the cause of action of the company, which would otherwise be defeated, can be asserted against the same defendant, relying on exactly the same facts. If we then go on to paragraph 28 on the following page, we see how Lord Justice Lloyd fits this within the statute. So he says 3 lines in, the original action asserting the company's claim against the former administrators cannot be determined without the substitution of the liquidator, whereas if brought by the liquidator under section 212 it can. Without that substitution, it could only, and would be bound to be, determined in favour of the defendant because of the section 20 defence. The claim would be struck out because of that defence, and it could not be decided on its merits either way as the proceedings stand. In terms of the rule, it cannot properly be carried on by the original party, the company, whereas it can be maintained and carried on if the liquidator is substituted. He then refers to the extent of the amendments required and says in the final sentence that it's the same claim in every respect, despite the fact that it is asserted by the liquidator on behalf of the company rather than in the name of the company itself. We then have similar observations in paragraph 30 on the same page. Although under the heading of discretion, there's simply another observation in the 5th or 6th line that the new proceedings would assert the identical claim to that which is made in the existing proceedings. And then finally, my lords, in the conclusion at page 236, in the final paragraph of the judgment, we see the conclusion at the final sentence of that paragraph. It seems to me that no error has been shown as regards his decision to allow the substitution of the liquidator in place of the company so as to assert the identical cause of action despite its incidental effect of overriding the limitation defence.
So putting this into the framework which I was outlining earlier, the critical language, as everyone agrees, is in paragraph B.
Yeah.
That's what we're concerned with. So just help me with this. What's happened in substance in Parkinson? Is it that the claim was originally brought against the administrators, but the liquidator is substituted as a defendant?
So the liquidator is substituted as claimant. The claim is brought by the
claimant.
company against the administrators.
Right.
That claim would be struck out because of the absolute statutory immunity which the administrators have. As Lord Justice Lloyd says, it could not be determined on its merits. It wouldn't get near that.
Right. So this is not a substituting a defendant case.
No, there is no example of substitution of a defendant in the authorities other than this particular line of cases, which all have as their origin Mr Justice Legate's Opus Dicta Insight Group. That they are an island unto themselves in the jurisprudence.
And realistically, there couldn't be such a case on broad construction, I think you accept.
No, quite. I mean, my complaint is the existence of that island. Yes. So 2 points can be seen to have been central to the decision in this case. Firstly, as I've said, the existing cause of action could not be determined on its merits because of the statutory release. It would have been bound to be struck out. That's what Lord Justice Lloyd says. And secondly, the cause of action which would be asserted by the liquidator was exactly the same in every respect as that previously asserted by the company. So we then come on, my lords, to the next case, which is Robertson Gill in the Supreme Court. It's a slightly unusual case that deals with actually a lot more issues than simply joinder and Section 35. And in fact, the ratio of the majority is not concerned with Section 35, but nevertheless, it contains some important dicta which repay attention. So this was a case where the claimant issued proceedings in negligence against solicitors who had advised the personal representative of his grandmother's estate. He sued in his capacity as a beneficiary. But realising then that those solicitors owed him no duty in that capacity, he sought to amend the pleadings to bring a derivative claim on behalf of the estate, which would, or at least arguably, would have required the joinder of the administrator. You see that in paragraph 1 in the judgment of Lord Collins at page 243. Now, Paragraph 19, which is on page 245, we see that the first instance judge held that there were no special circumstances justifying a derivative claim, that if he had found them, he would have held that joinder could be permitted. Paragraph 20 on page 246, we see the Court of Appeal's decision summarised, and we can see that the Court of Appeal really focused on section 35, and they held that joinder wasn't necessary for the personal claim to be carried on, and they could not permit the claimant to amend to plead the derivative claim without the joinder, because it couldn't succeed without the joinder. But we also see that the majority would have found that there were special circumstances if the joinder could have been effective. Now, the ratio of the majority in the Supreme Court was that the first instance judge was right to find that there were no special circumstances. Therefore, any observations on section 35 were strictly obiter, but a majority of the justices also addressed joinder and agreed that it was not available, and it was dealt with in detail in the judgment of Lord Collins, and therefore I would respectfully submit, obiter or not, it is obviously strongly persuasive. If we can pick that up at paragraph 21, page 246, Lord Collins notes that it is clear that the two firms of solicitors did not owe duties in the circumstances to Mark Roberts as a beneficiary under the will. So the claim which he had issued was simply a bad claim. There was nothing wrong with it as a claim, it was just a claim which was not going to succeed. If we then go on to paragraph 41 at page 252, Lord Collins says the representative claim is a claim involving a new cause of action, since the capacity in which Mark Roberts makes the claim is an essential part of the claim. And then at 43 and 44, we have key parts of his conclusion. Firstly, in 43, that it is not necessary to join the administrator in order to bring the personal injury claim. Because, as he said, there was no possible basis for any suggestion that the administrator would be a necessary or proper party to the personal injury, to the personal claim, sorry. And he then notes in paragraph 44 that the action could only therefore proceed if joinder was either not necessary at all, or the claimant could first amend to alter the capacity in which he sues without joinder, and then in a separate step join the administrator. And that's what his lordship then goes on to consider over a number of paragraphs that we don't need to concern ourselves with, addressing the question of whether joinder of the administrator was required. And we can pick it up at his conclusions on page 260, at paragraph 69, and he concludes that joinder was necessary from the outset. And then he says that it follows in paragraph 70 that the limitation problem cannot be overcome by amendments in separate stages so as to procure the result that the addition of the administrator would be necessary for the determination of the original action for the purposes of section 35B. He notes what the contrary argument would be, that you would first amend to change the capacity, that would then relate back, and that would always have been the claimant's capacity. Then it would be necessary to add the administrator, and then you could add the administrator in order to cure the defect in that case. But in paragraph 71, he says in the middle of that paragraph, it would be an abusive process for the amendments to be made in separate stages. As Lady Justice Arden said, it would be contrary to principle for the court to grant permission to amend the claim merely to reflect a change of capacity which would not enable Mark Roberts to proceed to judgment, but in any event, in a representative action, the administrator must be joined at the outset. So, although it was not the ratio of the court overall, that was the primary basis on which Lord Collins would have decided the case, though he also agreed that the judge made the right decision about there being no special circumstances. I think the only other parts of the judgment that I need to show your lordships are first at the beginning of the judgment of Lord Roger, at page 264, at paragraph 85. He said, at the end of the hearing, I was inclined to think that it might have been possible for the claimant to make the amendments in separate stages as outlined by Lord Collins, but having studied what he said, I'm satisfied that this would really be an artificial device. It would be to permit the claimant to do in 2 steps, something which the statute and civil procedure rules do not permit him to do directly in 1 step, and goes on to say he otherwise agrees with Lord Collins. And then finally, my lords, at page 266, at the beginning of the judgment of Lord Walker, at paragraph 95, he says he is in full agreement with the judgment of Lord Collins. So Lord Collins's observations on section 35 have the full support of 2 other members of the court. The other 2 members of the court didn't address the issue, so nobody suggested that Lord Collins was wrong either about the inability to join the administrator into the personal claim, or the inappropriateness of trying to get round the problem by dealing with it in 2 stages. And I particularly point to that because it's one of the answers to the suggestion of the claimants in Lee that that you can do what Master Teverson did in the Collingwood case, which was effectively do it in 2 stages, and I'll come on to that later. We can go from there, my lords, to the next case, Irwin and Lynch, which is the next case in the authorities bundle beginning at page 277. Another judgment of Lord Justice Lloyd in the converse circumstances of Parkinson Engineering. So this was a case we see in paragraph 1, page 279, where the claimant was the administrator of a company, and he alleged that a contract between the company and its directors to renovate a property was a transaction at an undervalue. We see that in paragraph 2. And we also see there that he had issued an application for a declaration to that effect and for findings of misfeasance and breach of trust under section 212 of the Insolvency Act. But the problem that he had was that section 212 is simply not available to an administrator. You see that in paragraph 4. So there was a complete procedural bar to the action, or at least that part of it. And so we see in 5 that the director defendants applied to strike out some of the claims, and the claimant therefore sought leave to add or substitute a company, and that was resisted in relation to one aspect of the claims, which was statute bar. We see that at the end of paragraph 5. We can then go to paragraph 10, where Lord Justice Lloyd, this is page 281, notes that there is a distinction, or he compares the positions in Irwin and in Parkinson Engineering. He says the distinction between this case and that is that in that case the company had a claim against the defendant, but the defendant had a complete defence to it, whereas here Mr Irwin does not have a relevant claim against the directors because section 212 does not give him the necessary locus standi to bring it. The company, on the other hand, does have a good claim subject to proof on the merits. What he goes on to hold, that was the distinction which counsel for the defendant said was crucial and meant that the power exercised in Parkinson shouldn't be exercised here. Lord Justice Lloyd goes on to say, as we'll see, it's not a relevant distinction. He then notes in the following paragraph, he refers to section 35, and he says, for the purposes of that section, a claim by the company is for the same cause of action as that asserted by Mr Irwin, but involves the additional substitution of a new party, so it is a new claim as defined in section 35(2). So we then see over the page at 15 the submission, as I've said, that was made on behalf of the defendants, which is that it made a difference that in Parkinson Engineering the claim was valid but subject to a complete defence, whereas the instant claim was vitiated by a lack of locus standi on the part of Mr Irving, who could never properly assert the claim at all in his own name. And that distinction is rejected by the learned Lord Justice on page 283 at paragraph 21. I won't read that out, but we can see there that he rejects that distinction. I would then go on to paragraph 24 over the page at 284, where Lord Justice Lloyd said, "It seems to me that the present case is one in which the substitution is necessary for the determination of the original claim, because the particular claim cannot be maintained unless the company is substituted as claimant. The original claim is a claim that the directors were in breach of duty in causing the company to enter into the contract, thereby causing the company loss. The claim is amended with the substituted claim that is identical. The original claim cannot be maintained successfully. The new claim can be maintained successfully, subject obviously to proof of the facts. If it is so asserted, it is the identical claim, but with a substituted and correct defendant."
Claimant.
I guess I'm sorry, claimant. Thank you. Those words, subject to proof of the facts, again indicate in my submission that we are not concerned here with substantive merits. The merits are yet to be determined. We are concerned with problems that prevent the court from getting to the merits. Lord Justice Lloyd then referred in the next paragraph to his previous judgment in Parkinson Engineering, and he says in paragraph 26, "Here the original claim is liable to be struck out, as it has indeed been because of lack of standing, but I see no good reason to regard the reason for the striking out as being a critical distinction between that case and this. I would also reject the contention that the cause of action is not the same because of the identity of the claimant. Sometimes the identity of the party might be, indeed often it might be, a vital distinction. But here Mr Irwin plainly asserted the company's cause of action and asserted it on behalf of the company, just as the substituted liquidator did in the Parkinson Engineering case. So the cause of action is identical. It is already pursued for the benefit of the company, but it is doomed to failure because of the lack on Mr Irwin's part of the necessary locus standi." And then goes on to say that substitution is possible. So again, we have a very strong emphasis here on the claims being identical, the causes of action being identical, in circumstances where the original claim would fail for reasons other than its substantive merits.
So just to go back to my sort of boxes, if you like, we've got this in the box that it's a substitution case, not a joinder case.
Yes.
It's a substitution of a claimant case rather than a defendant case.
Yes.
And the problem is one of standing.
Yes.
So that's why substitution is permitted.
Yes. And it is important to note, I mean, these two decisions are in many ways the sort of foundational decisions for this whole line of authority. They are both very unusual situations which may well only arise in insolvency situations where exactly the same cause of action can be asserted against the same defendant by two different entities in two different ways. They are not in themselves authority for any sort of expansive approach to section 35(6)(b). And Lord Justice Lloyd noted himself that the identity of the party might often be a vital distinction in determining whether the cause of action is the same. As I've already said, in the case of the defendant, my submission is that it will be. So there is certainly nothing inconsistent with anything in Parkinson Engineering or Irwin about the case that I advanced before your lordships. We need to go next, if we may, to the case of Nometi, and although there is a judgment of this court, I will, if I may, start briefly with the first instance judgment, which is at tab 18 and page 286. It's the judgment of Judge Cotter QC, sitting as a judge of the High Court. I'll take the facts from this judgment. This was a case involving a road traffic accident in Romania. The claimants were the passengers in the vehicle and the driver was killed. The car was insured by Sabre Insurance, the original defendant, but the holder of the policy was the driver's father, and his son was not insured to drive it. We see that in paragraph 2 on page 287. We see in paragraph 3 that the claim that was originally issued was one directly against Sabre under the European Community's Rights Against Insurers Regulation 2002. And we see in that paragraph quoted the material part of the pleading, which was said to give rise to liability on the part of Sabre. And the defence raised two fundamental problems with that claim, which meant that the regulations could not possibly apply. The first was that the accident was not in the UK, and the second was that the insured party was not the driver. We'll see that in paragraph 4. And so the claimants responded to that by seeking to substitute as defendant the driver's estate for the insurer and make instead an ordinary negligence claim against the driver's estate. And we see in paragraph 7, it recorded that in terms of what you would need to do to the pleadings to do that, all you would have to do is delete the text that we see quoted in paragraph 3. And that was permitted by the master, but set aside on this appeal and in turn then upheld by the Court of Appeal.
Which was the paragraph of the pleading amendment? Sorry.
Paragraph 7, my lord, records what the amendment would have been. 13 is where we see that the master permitted the amendment. Now, I can go from there. Well, what I will do, if I may, simply by way of pointer, is show your lordships that beginning at paragraph 27 on page 294, there is lengthy reference to Robertson Gill. And part of what the first instance judge took from that was a history of the relevant provisions that started with a report of the Law Reform Committee. Now, none of those at the bar today have troubled this court with that report, not least because in both, I think, Irwin and also in Mametti, it was said essentially that that is of really only historical interest and not much of a guide these days to the construction. But that was something the first instance judge thought was significant. And that was what led him in paragraph 41, and we see that at page 301, to say that the matters that I have set out support the general proposition advanced by Mr Palmer QC that the sections within the 1980 Act in issue in this appeal allowing the additional substitution of a party are necessarily restricted as to the very limited circumstances in which it is permissible to deprive the defendant of the accrued right of the limitation period. These sections are solely aimed at errors in the constitutional formality of the action relating to the parties joined to it or the capacity in which they sue or are sued, which made the extant action unsustainable. The additional substitution of parties had to be necessary to cure some defect. And all I note about that, my lords, is that that was a conclusion that the learned judge reached not as I have advanced it on the basis of the wording of the provisions, but on the basis of the legislative history. But then he goes on in paragraph 42 to say, as against this background, the direct question to be addressed is whether the substitution is necessary for the determination of the original proceedings, or in other words, whether the original claim could not be maintained or properly carried on without the substitution. It must be necessary for the maintenance of the existing action, not for the assertion of a new action. And as Lady Justice Hallett goes on to say in the Court of Appeal, whether or not you agree with what is in paragraph 41, what he says there in paragraph 42 is unimpeachable. And then we see his conclusion at page 303 at paragraph 46. where he says the plain reality is that the proposed substitution simply does not meet the necessary tests set out on any ordinary and the natural interpretation of section 35 and CPR 19.5. The intention, as I have set out, was never to facilitate a claim against a new party unless the circumstances met closely prescribed requirements. Here it simply cannot be said that the substitution of the estate is necessary for the determination of the original action. It may be thought necessary for effective recovery from an insurer, but that is a very different thing. I'll go from there directly.
Could you just help me with
Yes.
this? What does the judge there mean by met closely prescribed requirements? Because he seems to be contemplating at least the possibility in principle of substituting a defendant as a new party. But it was never intended to submit a claim against a new party unless the circumstances met closely prescribed requirements. So what is he envisaging would be good enough?
To substitute a defendant.
Yeah.
He doesn't say, my lord, and neither, to be fair, does Lady Justice Hallett in the Court of Appeal. This is a decision where, on any view, one might say the substituted claim was just perfectly obviously not the same claim. That leapt out at Judge Cotter, and it leapt out at Lady Justice Hallett. So neither of the judgments, I accept, of course, Judge Cotter does set out what he does at paragraph 41, but he then goes on at 42 to say, well, that's the test he's applying. In the Court of Appeal, Lady Justice Hallett certainly, I would say, and I'll make this good in a moment, didn't attempt to lay down a comprehensive description of the circumstances in which it might arise. She said, essentially, look at the wording, apply the wording, ask if it's within it or not, and this case isn't.
Speaking for myself, that is an attractive judicial approach, because ultimately our task is to apply the legislation, which is in issue.
Yes.
And we're not legislators, so it would be a fair response to say, well, the court isn't required to, and perhaps it would be unwise to try to give a comprehensive catalogue of the circumstances in which the power should be exercised. But it's a question of looking at the legislation and applying it to the facts of the case in front.
And my lord, I respectfully agree. Of course, the courts are often required, nevertheless, to look at the statute and ask what the draftsman meant by the words used. But I certainly don't hang my hat on. My whole case doesn't depend on persuading this court, for example, that I am right about there being some inherent limit of the use of the power to what one might call procedural defect. Because, as I say, if you apply the same claim properly, you will probably get to the same route anyway, and all that matters in the end, for my purposes, is that these two cases are not within it. So I certainly, with respect, have no difficulty with the court simply saying, well, we're going to look at the rules of the look at the wording of provision and apply them. I say that will still get me to where I need to go.
In the Nemeti case, what would need to be established in the claim against the estate of the deceased driver was that the driver had a duty of care, he breached it, it caused damage. That would be
The essence of it, yes.
the claim against the insurer would have been exactly the same, plus you're liable.
Yes, we don't have. I'm sorry, my lord, I didn't mean to speak over you. We don't have the regulations before us, but they are about as brief as a piece of legislation could be. They allow a claimant, in the circumstances where they apply, which is only where the accident is in this jurisdiction, and the driver of the car, or the person who would otherwise be the defendant to the claim, is the insured party, they allow the claimant to proceed directly against the insurer. But to make against the insurer exactly the same claim that the claimant would otherwise have made against the driver. And the only additional averments would be those which establish the right to go against the insurer, which would be the location of the accident and the fact that the insurer insured the driver. But it was those differences which are crucial to the substitution not being permissible, even though one can, although Lady Justice Hallett said this contention was too broad, and it's a very important observation, one can, in a sense, characterise both claims as being claims for damages for personal injuries based on the negligence of the driver. One can very obviously characterise them both in that way. But that's not enough of a similarity between the two claims to be within the provision. So if we can go then, my lord, to the Court of Appeal in the NFD, that's at paragraph, at tab 20, page 337. I'm very deliberately at this stage skipping over insight, because I will come back to it after.
But as a matter of chronology, insight comes in between the first instance and the Court of Appeal judgment.
It does, yes. And we will see that Lady Justice Hallett refers to the dicta which are the foundation of the claimant's case, but without any sort of comment on them. So the first point I would take from Lady Justice Hallett's judgment is at page 341, paragraph 14. This is simply recording, this is one of the multiple examples of this being said, recording that it was common ground that the wording of the rules was intended to have the same effect as the wording of the statute. Now, at paragraphs 19 onwards, and this is at page 342, we have the issue of paragraph 41 of the judgment below, and the criticisms that were made of it by the claimant in the Court of Appeal. And the main criticism that was made, as we see in paragraphs 20 and 21 and 22, was that the judge below had not been referred to either Parkinson Engineering or Irwin, and therefore was not aware of what counsel for the claimant described as a liberalised approach to these sorts of applications, which it was said that those cases were examples of. So he was saying, in essence, the judge below said this is a restrictive provision. Lord Justice Lloyd said it's a liberalising provision, and therefore the judge must have been wrong. Now, we see at paragraph 24 how her ladyship dealt with the submission that it was significant that the judge below hadn't been referred to Irwin or Parkinson. And in essence, without reading all of this out, there are 4 points that emerge from this paragraph. The first is that Irwin, she said, was not a rejection of the restrictive approach, but rather a reliance on the legislative history to establish the scope of the rules. That's the first point that I know she makes here. The second point that she makes is that being referred to Irwin might have spared the judge the need to get into the history, but that didn't mean that his conclusion would have been any different. And thirdly, and importantly, that both Parkinson and Irwin would have been within the judge's characterisation of the proper scope of the statute. In other words, they were both cases that could be regarded as procedural or locus standi errors. And then fourthly, her ladyship also noted in the final sentence that in both cases what was sought to be maintained was the identical cause of action. In paragraph 27, at the bottom of that page, we then see the reference to Insight Group, and at the top of 344, quotation of Mr. Justice Leggett's formulation of the test, which we'll come on to when we look at Insight Group. Interestingly, the final sentence of that paragraph is a criticism of that formulation by counsel for the defendant, not counsel for the claimant. But her ladyship provides no comment on Mr. Justice Leggett's test, either positive or negative. What she then says in 28 and 29 is that she finds the debate on whether Section 35 should be interpreted in the generous or restrictive fashion somewhat sterile, And the final sentence of that paragraph, I'm distinctly wary of adding any gloss to the statutory provisions, as His Honour Judge Cotter purported to do at 41. She then says in 29, I prefer to construe the unvarnished word of the section, which to my mind is clear. And I won't read all of that out, but she says in the middle of that paragraph, the question for the court therefore is whether or not a particular claim and proposed amendment come within its terms. The court has no power to allow a new claim to take advantage of the relation back principle unless it does. There is no power in general discretion to do justice where a mistake has been made of the kind made here. However, appealing Mr Burton may make the appellant's case. Now, in my respectful submission, Her Ladyship did not here reject outright Judge Cotter's characterisation of the circumstances in which the rule could be invoked. She said she was distinctly wary of adding any gloss, but this is, as I've said, a case where it was abundantly clear that it was simply not within the provision. There is no attempt here by Her Ladyship to determine the limits of the provision because it simply wasn't necessary. And as I've said, Judge Cotter's observation was one which was based on the legislative history, and Lady Justice Hallett was sceptical of the value of that, not one based simply on the wording of the provisions themselves. We then have Her Ladyship's conclusions at paragraphs 40 onwards. Paragraph 40, I won't read it out, but the essence of paragraph 40 is that if it was simply a question of doing justice, there might have been something in the claimant's favour. But then she says at the beginning of 41, at this stage of the process, it's not a matter of discretion, it is a matter of statutory construction. And then a few lines in, there is a flaw in Mr Burton's analysis of the original cause of action. When he listed the essential ingredients of the original cause of action, he stopped at the negligence of the driver and the relief sought. He ignored the additional and vital element in the original claim for relief against the respondents, namely the provisions of Regulation 3. The cause of action, the factual situation which entitles a person to a remedy against the respondents, may have been based on Mr Bureau's negligence, but it derived from statute. Had it not been for Regulation 3, there could be no claim against them. Regulation 3 requires certain conditions to be fulfilled. Thus, in a properly constituted claim under Reg 3, there would have been additional assertions in the particulars to the effect that the accident occurred in the United Kingdom and the tortfeasor was insured by the defendant. The claim for relief would have referred to the regulation, presumably sought payment from the defendant to the extent that the defendant was liable to pay the insured tortfeasor as per the regulation. The original claim was not, therefore, a claim for damages for personal injury against the respondents, as Mr Burton insisted. It was not a claim in negligence. It was effectively a claim for indemnity under statute, as the claim form made clear, limited the respondent's liability to their insured. And then in paragraph 43, contrasts that with the new claim being a claim for damages for in negligence for personal injury, and therefore at 44, thus although the late Mr Bureau's alleged negligence underlies both claims, the claims are not the same. It is not simply a matter of form. In substance, these are two different causes of action. So we see there, my lords, that Lady Justice Hallett expressed herself both in terms of the additional averments which the claimants would have to make in a claim under the regulations, but also the labels which would be given to the nature of the claim. Now, in my respectful submission, it's the former which is the more important point. It's the facts that constitute the cause of action that the focus should be on. Because there can be no dispute about the facts which are material in any particular case, whereas an action might be described in a number of different ways. And as we've already discussed, Her Ladyship did not accept that you could characterise the claim against the insurer as a claim for damages for the negligence of the driver, but in many ways one could characterise it as that. These sorts of issues should not turn on that sort of characterisation. They should turn on an objective and rigorous focus on the particular material averments that have to be made in each of the two claims. And so her ladyship concludes in paragraph 45, a deliberate decision was taken at the outset, no doubt for tactical and financial reasons, to sue one defendant, the respondents, on a particular cause of action rather than sue another defendant, the estate, on a different cause of action. After the expiry of the limitation period, the decision was taken to pursue the estate because the first cause of action could not be maintained. It was properly constituted but doomed to fail for substantive reasons. No amount of amendment could save it. The proposed substitution of a new party is not designed to maintain the original claim. It is designed to launch a new claim against a new party. A mistake was made, but not the kind of mistake that section was designed to remedy. The judge was correct, in my view, to find that the amendment is not necessary for the determination of the action.
Can I just ask you how on your analysis it would work if you had a situation of vicarious liability? If you were trying to sue, say, the employer of the driver, on your analysis, how does that fit into paragraph B?
Well, I say it doesn't, and your lordship will have seen from my skeleton arguments, it's a gauntlet I throw down to the claimants, because I would submit that vicarious liability is a situation where everybody's instinct would be that this is not the sort of thing that these provisions are directed at. If somebody issues a claim alleging that somebody is the employer of the tortfeasor and that the tort was committed in the course of the tortfeasor's employment, and partway through the proceedings realises that those allegations are going to fail for one reason or another, they weren't the employer, or they were obviously on the front of their own, and at that point seeks to substitute the original tortfeasor for the employer, I would respectfully suggest that everybody's instinct would be that that is not the sort of situation that Section 35 is directed at. And I draw some support from that, from the fact that it's not addressed in any of my learned friend's skeleton arguments, although squarely put an issue by me. And also with respect to the deputy judge below in Lee, it was also a point I made in my submission that isn't addressed in the judgment. And I do say with respect that is telling, because that poses a real difficulty for the claimants in coming up with a theory which catches all but only the right cases, as they would perceive it. If their case was going to be, oh no, vicarious liability is fine, we don't have an issue with that, well, they might have been expected to say that, but they don't. So if the court's instincts are, as I suggest, perhaps they might be, then there is a real difficulty there for the claimants in explaining how you can catch cases like these without also catching vicarious liability.
So we finished with Nemesi.
Yes, so at this point we'll wind the clock back and look at Insight Group at tab 19, beginning at page 309. The case, of course, concerned with the facts that are closest to those that we are dealing with here. A case where the claimants, we see in paragraphs 3 and 4, sued Kingston Smith LLP, but all of the material allegedly negligent acts were committed by the prior firm called Kingston Smith. The claimants obtained an order without a hearing initially, substituting the firm for the LLP. The defendants applied to set that aside. That was granted, and the claim against the LLP was struck out. So this was the claimant's appeal from Master Fontaine's decision striking out the claim. And in striking it out, Master Fontaine had held, in fact, that the circumstances were within B, but not within A. So it was a necessary party case. It was not a mistake case, but she had nevertheless refused discretion, which was why the claimants had to appeal. At page 315, paragraph 27, we have another observation that there's no suggestion the rule and the statute have different scope. Again, completely consistent with my case. Now, what the learned judge did first of all was address at some length the law in relation to A and the stake and the Sardinia Selkis case, and that begins at paragraph 29 at the bottom of 315. We are obviously not concerned with that provision, but it is relevant in my submission to understanding Mr. Justice Leggett's approach that he was critical of the distinction that Adelson and Sardinia Selkis gave rise to between the stakes as to name and the stakes as to identity. Those criticisms begin on page 318 at paragraph 39. They go on to paragraph 42, and we see it in particular at paragraph 55, pages 322 to 323. I will read that out, but Mr. Justice Leggett expressly questioned there why there should be this distinction between the stakes as to name and the stakes as to identity. But of course, as he said, he had to apply that distinction. And so in paragraph 57, he identified two possible circumstances that might arise in a case like this. So situation one, he says, is where the claimant sues the LLP in the mistaken belief that the LLP provided the services which are said to have been performed negligently, failing to recognise that the services were provided by the former partnership and not the LLP. And situation two is the claimant knows that the services were provided by the former partnership but mistakenly believes that the LLP is legally liable for the negligence of the earlier firm. The court has the power to grant relief in case one, but not in case two. And then, having considered all of the evidence that we don't need to trouble ourselves with, we can go on to his lordship's conclusion on page 329 at paragraph 83, where he holds, I won't read that out, but he holds that actually the evidence showed that this was a type 1 case, where the erroneous belief was that the LLP had done the work, and therefore it was a case that fell within A. Now, what he then went on to do at paragraph 86, and this is all agreed to be obiter, is consider in the alternative whether B could have applied. And we see at 87, this is simply for noting that the master had held that it was within B. And his lordship then considered the same authorities that we have looked at, though of course not Linetti in the Court of Appeal, but Linetti at first instance. We see that referred to in paragraph 90. We see in paragraph 91 that Mr. Justice Leggett agrees with the conclusion, though he doesn't agree with what Judge Cotter said in paragraph 41. He notes, as we've already seen from the Court of Appeal judgment in Linetti, that Judge Cotter hadn't been referred to Parkinson Engineering or Irwin. And then in paragraph 95, we see the principle that Mr. Justice Leggett took from those two cases, that substitution was permissible because the claim, as amended with the substituted claimant, was identical to that made originally. So his lordship took that as being crucial to the two decisions. And that's why he formulated his test that we saw quoted in Linetti in the Court of Appeal at paragraph 96, as being that the court has power to order substitution under 35(6)b and CPR 19.53b if 1, a claim made in the original action is not sustainable by or against the existing party, and 2, it is the same claim which will be carried on by or against the new party. Now, I respectfully endorse the requirement that the two claims be the same, of course, the second of those requirements, though I do respectfully submit that his lordship then didn't go on, in fact, properly to apply that test. But I do respectfully say that his first requirement, or the way he formulated it, doesn't properly capture the statute or the rules. It's too broad because it doesn't capture the requirement that the original claim cannot reach a determination on its merits unless the substitution is permitted. It expressed in the very broad way that Mr. Justice Leggett expresses it there, it effectively encompasses a claim that will fail for any reason. And we can see that that is then how he goes on to apply it when he looks at how it would have applied in paragraph 97. First of all, on the facts as he has found them to be. So in paragraph 97, his lordship considers would be the applicable in circumstances where the mistake is in believing that the LLP had done the work. And he holds in the first sentence that his first requirement is met. The claims made in the action are unsustainable. But I would observe in relation to that, obviously only unsustainable on the merits. There's nothing wrong with them as claims. You can serve a pleading alleging that Kingsman Smith LLP did the work, and that might or might not be wrong. There might be some debate about that. It might not be a clear-cut issue. So it is a problem with the merits of the claim and nothing more. But then he goes on to say, however, the second requirement is not satisfied, as the claims which the claimants sought to carry on against the firm were not the same claims as were originally made, as were made against the LLP. I have concluded earlier that the claims originally made against the LLP alleged that the LLP has been negligent in auditing the accounts of the second claimant and providing administrative and fiduciary services during the relevant period. In contrast, the claims asserted against the firm after the claimants had realised their mistake alleged that the firm and not the LLP acted as auditor and provided the relevant services. The new claims therefore allege different facts and are not identical to the original claims. So it's clear beyond peradventure there that the test that his lordship was laying down there was one which requires an examination of the particular facts that would be alleged in the two claims, and if they are different, they are not the same claim. But what he then does in paragraph 98 is apply B on the assumption that rather than it being a type 1 case, it had been a type 2 case. So let's assume for these purposes that the mistake had been in believing that the LLP had assumed liability in place of the firm. And he says there, picking it up about 6 lines in, if I'd accepted that analysis of the claims, then I would also have agreed with Master Fontaine that the requirements of CPR Rule 19.53b were met in this case. That is because if the original claims had asserted negligence in the provision of professional services by the firm, they would have been the same claims as those which are now pursued. The only difference would have been that the claimants were no longer contending that the LLP was liable and liable for the acts alleged. Substituting the firm because that contention was abandoned would seem to me to be equivalent in its effect to the substitution of the liquidator for the company in the Parkinson Engineering case and of the company for the administrator in the Irwin case. Now, just pausing there, in my respectful submission, it is quite striking that the same forensic rigour is not applied in paragraph 98 as was applied in paragraph 97. His lordship appears in paragraph 98 to treat the claims as being factually identical and as the liability of the LLP as being in effect a pure proposition of law. Now, I'll seek to make good in a moment why in my submission that cannot be right. But before I do that and leave this case, for completeness, I then just need to note paragraph 99. And in that paragraph, his lordship notes that essentially the effect of his decision is in these circumstances to undo the Sardinia Sulcus test, to do away with that distinction between mistake as to name and mistake as to identity, at least in these circumstances. It wouldn't matter whether you were within a whether it was a type 1 case or a type 2 case, because you would always be within one or other rule, and it would all come down to an exercise of discretion. And his lordship says here quite candidly, well, that's a good thing, because it gets rid of that essentially arbitrary distinction between the states of fact and law. And what I say about that with respect to his lordship is that, well, if that is the effect of the provisions, then of course so be it. But one should not seek to construe the provisions to have that effect. Now, to deal with my criticism of the approach to the facts in paragraph 98, I need to go to one further case briefly, which is Carrigan Finance and Thakura and Co. And that's at tab 9 of the authorities bundle. It begins at page 63. This was a case in which a mortgage lender was suing solicitors who acted for the lender and borrowers on purchases of flats, and the solicitors had failed to report subsales, which they knew about. We see all of this on page 66. The plaintiffs originally issued proceedings alleging breach of contract, negligence, and breach of fiduciary duty, but not dishonesty or intentional wrongdoing. However, after they had issued the proceedings and after the limitation period had expired, the House of Lords handed down its judgment in Samco, which meant that pursuing only those claims would severely limit the damages that they could recover. So they then sought to amend to add claims in fraud, conspiracy to defraud, fraudulent breach of trust, and intentional breach of fiduciary duty. And they did so on the basis that the new causes of action arose, well, in some respects they argued that they weren't new causes of action, but insofar as they were, they argued that they arose out of the same or substantially the same facts as the existing claim, and therefore fell within a different part of section 35. But the part of the judgment that I rely on is where Lord Justice Millett, as he then was, addresses the question of whether these new claims do introduce new causes of action or not. And that is at page 68, looking at the sideline passage, where his lordship refers to the well-known definitions of cause of action from Cook and Gill and Latang and Cooper. So taking Cook and Gill, first of all, the cause of action has been held from the earliest time in every fact which is material to be proved to entitle the plaintiff to succeed, every fact which the defendant would have a right to traverse. And then we see the reference to Latang and Cooper, and the quotation from that case: a cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. And he goes on, I do not think that Lord Justice Diplock was intending a different definition from that of Brett J. However, it is formulated only those facts which are material to be proved are taken into account. The pleading of unnecessary allegations or the addition of further instances or better particulars do not amount to a distinct cause of action. The selection of the material facts to define the cause of action must be made at the highest level of abstraction. So that is authoritative guidance on what cause of action means within section 35, the limitation, based on Cook and Gill and Latang and Cooper. And in that case, the holding was that intentional torts are different causes of action from unintentional torts. Now, I will, if I may, go to a couple of additional passages in Latang. We have Cook and Gill in the authorities bundle, but I don't think it's necessary to turn it up. But I will turn up a little more of Latang and Cooper, which is behind tab 7. And the relevant part of Justice Diplock's judgment begins at the very bottom of page 47. we see his judgment beginning. A cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. That is, of course, the passage we just saw quoted in Paragon Finance. I should say the issue that the court was concerned with here was whether there was any distinction between negligence and unintentional trespass to the person for the purposes of the limitation period. The holding was that there was not. It was a 3-year limitation period in each case. Now, going on, what his lordship noted was the historical concept of a form of action, and then goes on to emphasise what matters is the facts that give rise to the right to proceed. And so at B, he says, if A, by failing to exercise reasonable care, inflicts direct personal injury upon B, those facts constitute a cause of action on the part of B against A for damages in respect of such personal injuries. Then on the following page at 49, he also notes at 48 to 49 that certain fact patterns tend to acquire certain labels, such as negligence or trespass to the person or whatever it may be. But he again at E to F emphasises that what matters are the facts. He says it is true, just below E, that factual situation also falls within the description of the tort of trespass to the person, but that, as I have endeavoured to show, does not mean that there are two causes of action. It merely means that there are two apt descriptions of the same cause of action. So we are often inclined, as a sort of portmanteau expression, to use, for example, negligence to describe it as a cause of action, but it's not. We are using that as a sort of portmanteau expression for the facts which give rise to a claim to which one can attach the label negligence. But of course, in some cases, you'll be able to attach other labels to it, such as nuisance or some form of breach of statutory duty or whatever it might be. But what matters is the facts. That is what's crucial. So if we look at it in terms of the way Lord Justice Ditlock gives an example at B on page 48, if there are additional facts that give B a right against C in respect of the wrong committed by A, then that will be a different cause of action against C, albeit that it will still be founded ultimately on A's wrong. And so to bring in here at this point the example of vicarious liability, if B alleges that C was A's employer and that A committed the wrong in the course of his employment, those would be facts which, if proved, would give rise to a right to obtain damages from C. They form part of the cause of action against C, but not part of the cause of action against A. And it would be the same again if B wanted to allege that B and A and C had subsequently entered into an agreement under which A was released from any liability and C instead took that liability upon itself. That would again be a different cause of action against C, in which additional facts would have to be alleged beyond those which would found the claim against A. And fundamentally, and this is where I respectfully take issue with Mr. Justice Leggett in Insight Group, is that bases of liability do not exist in a factual vacuum. And he was wrong with respect to say that changing the identity of the defendant in a Type 2 case was just like changing the claimant in Parkinson or in Irwin, because in those cases there were identical causes of action which could be asserted by different entities in different ways. Who could assert the cause of action and how they might assert them are not themselves part of the cause of action. Whereas if you are alleging that a particular defendant is liable, there will be necessary facts that have to be proved in order to establish why that particular defendant is liable, and they are part of the cause of action. So there is a really important qualitative difference between the Parkinson and Irwin type situation and the sort of situation that we're concerned with here, and that Mr Justice Leggett is dealing with in paragraph 98 of Insight Group. So if we just look at these cases, let's take the facts of these cases. When Office Properties issued proceedings, there was a factual averment, or would have been had they ever formally served the claim, that BDB Pitmans was the successor practice to Pitmans for the purpose of the SRA minimum terms. And if they had persisted in that claim, that was an allegation which, if it was disputed, they would have had to prove in order to make their claim good, if it could in fact found liability. And it might or might not have been disputed. In this case, there is in fact no dispute. Everybody agrees that BDB Pitmans is a successor practice in relation to Pitmans. There are lots of disputes between insurers where that is very much an issue. So that is a factual, a crucial fact that formed part of the cause of action asserted in Office Properties against BDB Pitmans that did not form part of the cause of action now asserted against Pitmans. And in relation to Lee, the position is even more extreme because we've already seen the 4 pages of pleadings of facts which are alleged in order to make BDB Pitmans liable for anything that Pitmans might have done. And if, as per Mr Justice Leggett, as he then was in Insight Group, it's enough to say, as he does, well, you're making the same allegations of negligence against fundamentally the same person or the same entity, then, as I said earlier, and I won't repeat my submissions on this, you can't exclude vicarious liability. If you think that vicarious liability should be excluded, you won't exclude it on Mr Justice Leggett's formulation, because you are still fundamentally alleging the same thing was done by the same person. You were just either alleging or not alleging as another entity bears liability in respect of that tort. So just to complete my tour of the authorities, and before I go to the judgments below, there is one final case that I need to mention briefly, and that is Mr Justice Mann's decision in various claimants in G4S PLC. That's at tab 21 of the authorities bundle. It's quite a lengthy judgment, and which concerns a number of amendment-related issues. One of the principal decisions that Mr Justice Mann made in this case was that 17.1, CPR 17.1, did not allow you to add a claimant as a new party as of right before serving the claim form, and he also decided that the requirement for a claimant added as a party to a given written consent couldn't be met by the solicitor's signature on the statement of truth. Now, both of those decisions were subsequently not followed by the divisional court in a subsequent case called Roy. I'm not going to trouble the court with that. I'll leave it to my own friends to decide if they want to do so. And that, of course, is right. It doesn't in any way affect the quite separate observations that Mr Justice Mann made about section 35 of the Limitation Act and CPR 19.63. And I would ask the court to look at page 373 in paragraph 152. And I'd say that I simply offer what is in paragraph 152 as the view of another puny judge which supports my submission on the meaning of properly. So after some consideration of the previous authorities, which I don't propose to go through, Mr Justice Mann said at 152, it seems to me that insufficient attention has been paid to the word properly in the provision. While it is not possible to define its precise effect, it seems to me that it is intended to correct errors of the kind in Irvin and Parkinson, which are in the nature of locus standi errors. The word would be unnecessary if the provision were to have the broad effect which Leggett J's analysis would give it. An interpretation along these lines is the interpretation which I prefer, and is not inconsistent with the Court of Appeal authorities which bind you. Now, I don't want to get too bogged down in this authority. I do accept that there are legitimate criticisms that can be made of some of the reasoning in paragraph 151. I certainly do accept that it doesn't necessarily follow from Mr Justice Leggett's formulation of the approach to B that you are thereby doing away with any relevance of A, but that's really a separate consideration from the point that I take from 152, which was simply a judge's instinct that that word properly is meant to indicate something. I should say, just for completeness, although of little significance in this court, that the claimants in Lee call this passage obiter, and it's not actually obiter, because there was a quite separate question that related in part to some of the existing claimants about whether some of them could alter the names they were suing under. These were all problems on the claimant side. I'll just give your lordship the reference so you can see it. It's 118 to 120 of the paragraph numbers, and 367 is the page number. And we see two paragraphs where Mr Justice Mann makes substantive decisions based on his view of how section 35(6)b should apply. They're paragraphs 256 at page 386 and paragraph 266 at page 387. I quite accept, lest it be said, that it is not entirely clear how exactly Mr Justice Mann interpreted 35(6)b, and I certainly have no desire to be seen to be hanging my case on this authority. As I say, it's simply the observation of another High Court judge that maybe this is intended to be more restrictive than Mr Justice Leggett thought. So, my lords, that concludes my tour of the authorities, and I'll go from here to the judgments below themselves. And I'll start with the judgment in Office Properties, which begins at page 53, tab 7, for those who have them in the core bundle for Office Properties. With respect to the learned judge, I don't propose to go over any of his survey of the same authorities that we have looked at. It is perhaps interesting to note, though, at paragraph 39, page 67, that the learned deputy judge did have some difficulty with Lady Justice Hallett's conclusion in Nanetti that you couldn't characterise that as a claim, the original claim as a claim in negligence. And I'm not sure with respect to the learned deputy judge that the answer is simply that it was badly pleaded. Actually, we see what the averment is in Judge Potter's judgment, and it seems perfectly clear. But the analysis begins at page 68 and paragraph 42. And the nub of the reasoning is in paragraph 44. And we see, first of all, that the judge appears to begin by accepting my proposition that claim for these purposes means cause of action following those classic definitions. But then he goes on to say, in my judgment, Mr Lawrence KC is correct in saying that one cannot apply that definition literally to ground B, because the minimum facts which have to be pleaded in order to found a claim against one party will necessarily be different from the minimum facts which have to be pleaded to found a claim against a substituting party. And with respect to the learned deputy judge, that obviously begs the question. He then goes on to say, the necessary difference is the inclusion of facts intended to show why the original party or the substituted party, as the case may be, is the right party. The allegation in the original claim form that BDB was liable of the successive practice was not a necessary ingredient of the claim for loss caused by Pitman's negligence and was added solely in order to show where liability should attach to BDB. by necessary inference, it was of course a necessary ingredient of the claim against BDB Pitmans. And what the judge appears to be saying there is that for the purposes of comparing the two claims or the two causes of action, you should disregard facts which are included solely in order to show why liability should attach to the particular defendant. And I say with respect, that is obviously far too wide a formulation. It's going to capture every case in which you just sued the wrong defendant. Because if the underlying basis for the claim, the things that happened are the same in each case, the only difference between the two claims will always be the particular facts which make that particular defendant liable. It would obviously capture cases of vicarious liability, and it would also, in my submission, capture the facts of Nemeti. If this formulation were applied, Nemeti would have been wrongly decided, because the additional facts alleged in Nemeti were only ones which went to making the insurer liable. And if you ignore those, you do have the same claims. So that cannot be the right test in my respectful submission. That's all I need to say about the Office Properties judgment. And then I can deal with the judgment in Lee quite briefly, because with respect to the learned deputy judge, essentially, she followed Insight Group and followed Office Properties as a very recent decision by a judge of coordinate jurisdiction. But just to show your lordships how she dealt with those issues, the judgment begins in the Lee core bundle, tab 6, page 55, and the relevant part begins at page 78, paragraph 80, after she's dealt with the summary judgment application. So this is just by way of signpost. I'm not going to go through all of this again. It contains a survey of the same authorities. The reasoning begins at paragraph 100. We see at paragraph 100 the title of what our case was, which was the same as it is now, and we see at 102 the judge says that she's going to follow Office Properties, both because she ought to and also because she considers it to be correct. At 103, the learned judge took a similar approach to Mr Halpern in Office Properties, but she abstracted or addressed the cause of action as an even greater level of abstraction. Because we see in the middle of that paragraph, in this claim, the cause of action, professional negligence, is identical whether the defendant is Broadfield or Pitmans. So that's zooming out even further than Mr Justice Leggett would have done or Mr Halpern. And at that level of abstraction, then you really have done away with the need for A. If all you need to say is I'm trying to bring a claim for professional negligence and I can alter the parties however I like in order to make sure that I can pursue a claim that I think I can win, then you have entirely departed from the wording of the statute. But then she goes on to say the difference in defendant simply relates to which party has the liability for its consequences if the negligence is established. In my judgment, the fact that another step has been pleaded in the original claim to account for how Broadfield is sought to apply the liability for the alleged breaches of professional duty of care does not prevent it being the same claim for the purposes of ground B. And then just for completeness, I should note, my lords, that in paragraph 104, the learned judge gave, as an example of a previous similar case, a case called the tintometer. You'll see that referred to in the third line up. I don't propose to go to it. We have it in the authorities bundle. That was in fact a case that was agreed to be within A. So if the learned judge thought that it was a case under B, I'm afraid she was wrong.
So agreed in what context?
Agreed by the parties in
Yes.
the tintometer to be a case within A. It was all about discretion. And in 105, then the judge concludes by agreeing with Mr Justice Leggett insight group. So, to conclude, my lords, I then propose to deal with some of the points that are made by the claimants in their skeleton arguments. Firstly, we're dealing with my proposition 4, the significance of the words properly carried on. The claimants in Lee make a number of points in their skeleton argument about that, and I'll address some of those now. So, paragraph, if we can look at paragraph 5, sub 5 of the Lee skeleton argument, and in terms of bundle pagination, it's page 34. What is said in effect in subparagraph 5 on that page is Parkinson is against me because Parkinson wasn't a case that would have failed for constitutional procedural reasons. Now, as I said when I opened the appeal, it may not be possible to come up with a perfect description of all the situations that are envisaged, but essentially one could say you know it when you see it. The key point is that Parkinson failed for a reason other than its substantive merits. It couldn't get out of the gates because of the statutory release. It would have been bound to have been struck out. But also, I say in answer to this, that in the Metti, Lady Justice Howard acknowledged, as we saw at paragraph 24, acknowledged that both Irwin and Parkinson were cases that would have met Judge Potter's description of the scope of the provision. So that's the answer to that. At subparagraph 6, that there is what amounts to a complaint that the appellant's construction will restrict the court's ability to do justice. But of course that's going to be the case on any construction where there isn't an unfettered discretion. And as we have seen said more than once, the tail of discretion does not wag the dog of construction. In subparagraph 7, it said it's difficult to understand why the law might draw a distinction between what has been described as locus standi or constitution cases and cases where the wrong defendant has been identified. But in my submission, the distinction that we would set up is a perfectly coherent one. Of course, the starting point is always all of these provisions deprive the defendant of an accrued limitation of defence. Now, that does not mean, of course, as Lord Scott says, you therefore have to assume that you should be as favourable to defendants as possible. That is no part of my submissions. But Parliament has decided in those circumstances in what situations those rights can be set aside and in what situations they have not. It is inherently rational for Parliament to have decided that the power should be limited to procedural or constitutional issues, as opposed to cases where the claimant has simply brought a claim that will fail, that is bad on its merits. And any complaint about the rationality, which there seems to be here, of excluding the states as to identity, is a complaint about the construction of A and subunits office and agency. And that's not what this case is about. And then finally, in relation to this issue, I would just note what the learner friends say on page 36, and what is actually paragraph 5.8, little Roman 4. So there has obviously been some commendably exhaustive research to try to identify any established meaning of the words properly carried on. And the conclusion is those words don't seem to have any established meaning. But my learner friends note that there was, under the old rules of the Supreme Court, in relation to service out of the jurisdiction, the concept of an action properly brought, which is the subject of the Ellinger case, or Ellinger case, And Millennium Friends also yesterday produced another authority in the Privy Council, more recent from the Isle of Man, which deals with an equivalent provision which continues to exist there. I can cut through all of this, I think, by saying those cases essentially establish that properly brought is akin to the summary judgment threshold. And of course, it's a test that we would all recognise from the current formulation of the circumstances in which you can obtain permission to serve out of the jurisdiction on the necessarily proper party where you have an anchor defendant. Now, in response to that, I say firstly, well, I don't accept that this establishes that properly is a term of art in that way. The fact that there is some understanding of what properly brought means doesn't per se translate across to properly carried on. But I also say that this is an inherently self-defeating submission. Because if the test is you can survive summary judgment, that's exactly what the claimants in Lee have done. We tried to get summary judgment and we failed. So it has been established that the claim in Lee on this test is being properly carried on and therefore is necessarily outside the section. And then move on to finally my final proposition, which is that these are just not the same claims. They are not the same cause of action. Now, in the letter from Mr. Lawrence's skeleton argument in Office Properties, at paragraph 34, and that is page 44 of the core bundle, he appears to accept in the fourth or sixth line from the end, addressing what Mr. Justice Mann said in the G4S case, he appears to accept that same claim means same cause of action, because he writes, with respect, Manjay did not attach sufficient weight to the fact that the requirement that the same claim or cause of action must be advanced pre and post substitution of the relevant party limits the scope of the rule. But nowhere, with respect to Mr. Lawrence, does he actually assert, let alone try to make good in this skeleton argument, that the two causes of action are the same. The closest he comes is in paragraph 22, which is at page 40 of the bundle, where he effectively approaches the question of same claim by reference to what he calls the gist of the claim, which he reduces to Pitman's negligence caused the claimant's loss. Now that is obviously not the same as the causes of action being the same. And the problem, as soon as you start abstracting from the precise cause of action, is of course where do you stop? As we just noticed with the way Ms. Shea approached the issue in her judgment in Lee, you can go all the way up to, well, it's just a claim for damages for professional negligence. And certainly, Millennium Friends' formulation in terms of gist would probably capture the situation in the Netty. After all, the gist of the claim was claimants injured in road traffic accident as a result of negligence of driver, would certainly capture vicarious liability. Millennium Friends in Lee make some additional points which seek in particular to address what might be called the practical amendment questions. And so I picked this up at paragraph 8, subparagraph 2 at page 38 of the Lee core bundle. So they say in 8.2, whether it is the same claim or not might simply be tested by asking whether if substitution were ordered, it would be necessary to make any amendments to the claim for it to be maintainable against the new defendant. And effectively they say, well, we can just leave the pleadings as they are, or all of our 4 pages of averments about why BDB Pitmans are liable will be pure surplusage, but that's fine, that can just sit there and we can ignore it. And now you've got the same claim against Pitmans. Now, that is obviously with respect to an exercise in elevating form over substance. The causes of action are the averments which are material in each case, and that is not to be answered by asking how well or badly the claim is pleaded, or looking at how somebody has in fact pleaded the case. You have to analyse the causes of action and simply put them side by side and see whether there is identity in each case of the facts which it is material to avert. And another obvious answer to this submission is that it would result in effectively a one-way situation where you'd be okay if all you needed to do to substitute was cross things out of your pleading, but you would have a problem if what you needed to do was add things in. I would suggest that nobody could say that that would be a coherent or principled approach to the statute or the rule. At paragraph 8.3, I simply note for completeness there's effectively the same claim, the same submission as was made by the letter from Mr Lawrence, noting well you can just characterise this as a claim for damages for professional negligence. I dealt with that. At 8.4, it then said the fact that we're alleging novation, estoppel, and acknowledgement doesn't change the fact that it's a claim based on Pitman's negligence. Well, of course, that much is true, but then they say novation, estoppel, and acknowledgement are not claims or causes of action, but merely rules of law that might be invoked in relation to a claim or cause of action. But of course, they can only be made good and can only give rise to BDB Pitmans liability if the factual averments that underpin them are made good. If all of that material was removed from the pleading, there would be no coherently pleaded case against BDB Pitmans. There would be no basis at all on which BDB Pitmans liability was being asserted. The facts relied upon in order to found a case on novation, estoppel, or acknowledgement are part of the cause of action that these claimants say they have against BDB Pitmans. At subparagraph 5, which follows, we then have the reliance on Master Teverson's decision in Collingwood that I mentioned earlier. To deal with this, we should turn up that case, which is at tab 26 of the authority bundle, beginning at page 477. This was another case of merger where the claimants sued the subsequent entity. Now, the particular mistake they were held to have made in that case was that they thought that Irwin Mitchell LLP was the same entity as Thomas Egger LLP. So they did plead that it had been Thomas Egger LLP that had done the work. What they had failed to appreciate was that Thomas Egger LLP was not the same thing as Irwin Mitchell LLP. And that was, it also has in common with this case that the claimants for the defendant's application for summary judgment, many of the arguments about novation were the same as in Lee, but in that case they all failed and that was determined in the defendant's favour. So then the master came on to the claimant's application for substitute, and he held, so the primary basis for his decision was that this was a case under A, and he reached that conclusion at 494, going on to 495, paragraph 91. Slightly curiously, however, counsel for the claimants wanted to argue or made their primary case that in fact this was a case under B, and so the master dealt with that at 92 onwards. He notes what the section and the rule provide. He refers to the test set down in paragraph 96 of Insight Proof. He refers to submissions made in paragraph 94, and I don't need to go through those, But he then says at 95, I have already concluded that the claim against Owen Mitchell has no realistic prospect of success. In those circumstances, I think it is open to the court to strike out paragraphs 4 and 5 of the particulars of claim, thereby removing from the particulars of claim any claim that Owen Mitchell LLP was liable in law to the claimants. Once paragraphs 4 and 5 are struck out, the court would, in my view, have jurisdiction to substitute TL as defendant to the claim, either under A or B. In neither case is there, in my view, any basis for retaining or necessity to retain Owen Mitchell LLP as defendant. So that's what the learned friends in Lee invite the court to endorse, that you can effectively do this in stages. You remove all the averments that go to making BDB Pitmans liable, and then you say, well, now all we've got is a claim against Pitmans, and therefore it's the same claim. Now, before I criticise the master's reasoning, I do note that it appears implicit in his decision that he thought he couldn't otherwise do it. And with that, I would respectfully agree. He seems to have thought that there was a difficulty with simply substituting in those circumstances. But there are then, in my respectful submission, obvious difficulties with the way the master then dealt with it. And I make 4 points about that. The first is, following what their lordship said in Roberts, it is an abusive process to do in 2 stages what you cannot do in 1. If this is just a device to try to get down the problem that you can't actually bring this within the rule, then it's inherently inappropriate. My second point is that it wasn't an answer or didn't reflect the findings that the master had made on the summary judgment application just to remove those 2 paragraphs, because the defendant's application was for summary judgment on the claim. The way you reflect success on an application of that kind is you dismiss the claim. It wasn't an application by the defendant to strike out 2 paragraphs from the particulars of claim. And simply striking out those 2 paragraphs does not reflect what the master in fact decided. And an additional problem is that removing those 2 paragraphs still leaves no claim against the existing defendant which could succeed. So you haven't met the problem at which the summary judgment application is directed. The third point is that the answer here again is that it's a question of substance, not form. You can't change the fact that the material averments are different in each case just by exercising Nelsonian blindness as to the new ones in the particular case. And fourthly, again, this is a one-way approach. This is an approach that only seems to work if you're removing material, not if you're adding it. And then the final point that my learned friends make at sub-paragraph 6 of their skeleton argument, still on page 39, is they say that there's authority that B can be invoked after trial. And they refer in support of that to Merit and Bab. I didn't propose to turn that up, but of course I will to your lordships, but the essence of that is that a claim was being made in respect of negligence by valuers, where the sole claimant was only one of 2 legal co-owners, and the other co-owner had never been a party to the proceedings. But under a deed of trust, the co-owner that was the named claimant also had the whole of the beneficial interest. Nevertheless, it was a problem with the claim that the co-owner had not been joined. The claim properly had to be brought by both co-owners. And it had got all the way to trial and all the way to an appeal without the other co-owner ever being joined. And what this court held, having dealt with the question of breach of duty, was that even at that stage on appeal, the court could exercise the power in B to join the co-owner as a party, because without the co-owner as a party, there was a procedural bar to giving the claimant the judgment to which he had otherwise been held to be entitled on the merits. So that case, I say, is not a problem for me at all. It's entirely different circumstances where the claim had succeeded on its merits, but there was a hurdle in getting to the pot of gold on the other side that the claimant could not cross without the co-owner being a party to the proceedings. That was obviously a straightforward procedural problem with the proceedings that had nothing to do with its merits. And the fact that you can do that at trial and even in this court sheds no light on whether the Lee case is within section 35(6)(b). On the claimant's own case, the Lee case is straightforwardly a good claim and properly brought. We say it will ultimately fail on its merits, and the claimants disagree with us. In my respectful submission, that is a situation plainly outside the confines of these provisions. So, my lords, without in fact using the half an hour which I'm technically allotted under the timetable after the short adjournment, those are my submissions.
That's very helpful. May I check if there are any other questions? No, we're very grateful to you. Mr. Lawrence, do you want to start now, or do you want to start at 2 o'clock?
I can take your lordships, I think, very swiftly to one case, which my learned friend mentioned in passing. It might be helpful to do that, just to get that out of the way before the short adjournment. It's the case which we find at tab 25 in the authorities, page 452. This is the first of the 3 cases in which the arrangements by which Pitmans, an old-fashioned partnership, became an LLP, have caused procedural difficulties for claimants. The second and third of those cases are obviously before this court. Now, this is the first of the trinity. And the claimant here, I acted in this case, the claimant here was Tintometer Limited. It was a case about pensions negligence, obviously. And as my own friend rightly said, the distinction between this case and the 2 cases that are before this court is that in Tintometer, as it happened, the lawyers acting for the claimants made a mistake of a type which is different to the mistakes that were made in the present case. In the Tintometer case, the lawyers mistakenly supposed that BDB, the second entity as it were, the LLP, had provided these services which were alleged to have been negligent. In the cases before this court, of course, the mistake made by the claimants was of different nature. It was a mistaken assumption that events following the taking place after the relevant negligence had caused BDB to assume or to be affixed with liability for the negligence of the Pitmans firm. The consequence of the fact that the mistake in the Tintometer case was of a different nature was striking. It meant that the claimants in the Tintometer case were able to show that the mistake was of, as it were, the right sort to cause the jurisdiction under subparagraph A to be engaged. It was the right sort of mistake pursuant to the test laid down in the Sardinia Celsius case.
it followed that the court had jurisdiction to allow substitution. The only issue was discretion. The court heard submissions about the very close connection between the original firm Pitmans and the LLP into which the Pitmans practice passed, and had no difficulty at all in concluding as a matter of discretion that the substitution should be permitted. So that was case one, and I simply mention that case. I needn't go to any part of the judgment. I simply mention that case because that illustrates or indicates the reasons why Mr. Justice Leggett, as he was in the Inside case, was expressed, said that he was content to come to the conclusion that the jurisdiction pursuant to subparagraph B was relatively wide, as his lordship indicated in the obiter passage that my own friend has gone to, because if the subparagraph B jurisdiction is wide, that's the jurisdiction we are considering here, then that will address the inconvenient consequences that might otherwise flow from the highly technical nature of the distinction that was drawn by the Court of Appeal in the Sardinia Celsius as to the concept of mistake as defined in subparagraph A. So I simply go to that as a very short, by way of a very short introduction to my substantive submissions, and that's going to be in a moment if that suits the court.
Thank you very much. We will sit again until.
Thank you.
Court rise is able.